Hi everyone. Today we're going to talk about the judicial branch and the courts. The first thing that I want to ground us in is the Constitution. So I'm going to read the sections of the Constitution that apply here. So there are specific judicial branch powers stated in the Constitution in Article 3, Section 1. It says, "The judicial power of the United States shall be vested in one Supreme Court. The judges both of the Supreme and inferior courts shall hold their offices during good behavior." So it is a lifetime sentence, and the Supreme Court justices stay as long as they have, quote, good behavior. There is only one Supreme Court as identified by the Constitution, but as you'll see in a second, Congress can create additional courts, which it has. So the legislative branch does check the power of the judicial slightly when it does the following. It says, "And in such inferior courts as the Congress may from time to time ordain and establish." That's in Article 3, Section 1, meaning that the legislative branch does create these lower courts. In addition, the executive branch can limit the power of the judicial branch, because the President shall nominate and, by with the advice and consent of the Senate, shall appoint judges of the Supreme Court. And that's in Article 2, Section 2, Clause 2. So the President appoints judges, and that's both for the Supreme Court and inferior courts. And then the Senate confirms those judges. Now there's a couple different kinds of cases. You have criminal cases and you have civil cases. A criminal case is like murder or rape, something in which there is typically bodily harm. In criminal cases, guilt must be proven beyond a reasonable doubt, meaning that everyone must agree, all the jurors must agree that the person is guilty. And that's why you may have heard the phrase innocent until proven guilty. In the criminal cases, the government is always the prosecution. So you may see like U.S. versus somebody. That is a criminal case. There are two steps in criminal cases. You have a grand jury to look at the evidence, and then you have the trial jury. In civil cases, these are the most common. These are like divorce or custody. They're between people or two sides. Punishments are not usually going to be jail time. Instead, it's going to be some sort of payment. Guilt is based on a preponderance of evidence, which means that the majority of the evidence must point in a certain direction. This is different from criminal cases where you have to have 100% certainty that a person is guilty. It's always going to be plaintiff versus the defendant. So the plaintiff is the person bringing up the case. And the civil cases are always heard by trial juries. So there's only one step there. In terms of phrasing, both criminal and civil are going to be phrased accuser versus the accused. And you should know that not all cases actually go to trial court. The majority of cases, 90% of cases, are actually settled by a plea bargain. So this may be someone admitting guilt, or this may mean that instead of going to court, the plaintiff would rather have payment, and the defendant agrees. And so not all cases actually get heard by a jury. Now, there is a hierarchy in the court system. You have the federal court system and you have the state court system. Most cases get held in the state court system. You have original jurisdiction and you have appellate jurisdiction. Jurisdiction just means that the crime is being heard in the location in which it was committed. There are some cases in which federal courts have original jurisdiction. But in most cases, as you can see here, 100 million filings per year, most cases have original jurisdiction in state trial courts. Okay, so I'm going to go through the state system first. And in the state system, there's about 100 million filings per year. Judges are typically elected by the people. If somebody disagrees with the results of this trial court, you can go to an appellate court. And these appellate courts hear about 300,000 cases per year. And basically, they are reviewing the results from the trial courts. If you are still not satisfied, you can go to a second appellate court, which is the highest of the state courts, and they handle about 95,000 cases per year. If the plaintiff wants to have a writ of certiorari, that means that they want the case to be heard by the Supreme Court. They can then appeal to the Supreme Court. Let's do the federal court side. On the left, you have original jurisdiction, and on the right, you have appellate jurisdiction. So the U.S. District Courts handle about 325,000 cases per year. They're heard by one judge. The only times in which the United States has original jurisdiction is the law at issue is a federal law. It involves a treaty. It involves a matter of the Constitution, like freedom of speech. The U.S. government is a party to the litigation, so maybe somebody is suing the U.S. government as a whole. Or civil suits between citizens of different states if the amount in issue is more than $75,000. Let's say you want to appeal, you go to the U.S. Court of Appeals. These are called circuit courts. There are 12 circuit courts. Hearing about 60,000 cases per year. You have 3 judges that hear the case. Federal judges, which is all of these on this side, are appointed by the president. These appellate courts, these circuit courts, do not have original jurisdiction. The location in which the case is heard depends on the region of the circuit court. So, for example, these 3 states here get served by circuit court number 5. In these circuit courts, the judges hear cases from lower federal courts. It could be U.S. regulatory commissions, legislative courts, including the U.S. Court of Federal Claims and U.S. Court of Veterans Appeals. Sometimes these cases get pushed up to the Supreme Court through a writ of certiorari, and the Supreme Court can then hear those cases. The Constitution does list some cases in which the Supreme Court has original jurisdiction, and that is when there are 2 or more states involved. So let's say it's the state of Texas versus the state of Mississippi. It could be the United States versus a state, so United States versus Georgia, for example. If it involves foreign ambassadors and other diplomats to foreign countries, and it could be a citizen of another state, a state and a citizen of another state if the action is begun by a state. Okay, but these are extremely, extremely rare. The Supreme Court gets to decide which cases it hears, and out of the thousands of cases that are brought to it, it only ends up hearing about 75 to 90 cases. There are 9 justices on the Supreme Court that hear these cases. When the U.S. Supreme Court is acting as an appellate court, it's serving through judicial review, where it's reviewing the processes of previous courts. The highest state courts have to have first heard the case before it goes to the Supreme Court, and sometimes the Supreme Court serves as a court of military appeals. So how do you bring a case to the Supreme Court? First of all, you have to have a case. If something hasn't happened yet, you can't go to the Supreme Court. So the Supreme Court does not serve as an advisory committee. Something has had to already have happened, and there has to be a case surrounded by it. That case is sometimes known as a controversy. It has to have been already heard by as many courts that there are. Then you can petition for a writ of certiorari. This is in an appellate proceeding. And then the Solicitor General chooses which cases get heard. So that's why only 75 to 90 cases get heard per year, because the Solicitor General actually denies most writs of certiorari. Once the petition gets through the Solicitor General, it goes to the cert pool. Once it's in the cert pool, to actually grant the certiorari, 4 of the 9 justices have to agree to hear it. So they have to agree to actually listen to the case and to judge on it. Both sides of the case submit briefs. These are legal documents explaining both sides of the case. Oftentimes, there aren't just 2 briefs, there's actually several, because amicus curiae, or friends of the court, often submit briefs as well on behalf of one of the sides. Then the oral arguments take place, in which the 9 justices listen to the arguments of each of the sides. Most of this time is actually the Supreme Court asking questions to the lawyers for each side of the argument. After oral arguments, SCOTUS, the Supreme Court, conferences, and at least 5 of the 9 must agree in order for the case to come to a decision. Sometimes they actually issue a remand, which sends the case to a lower court. If 5 of the 9 agree, that is considered the final holding. The Chief Justice of the Supreme Court will write the majority opinion. It is a document that is binding to lower courts. It is what is considered the precedent. Sometimes the justices that disagreed with the opinion will write a dissenting opinion, but this is not binding. It just could be used in future court cases to re-examine certain laws, but it's not binding. Once the majority opinion has been written, that's considered a holding, and it's binding by the lower courts. So that is the process of getting a case to the Supreme Court. Now, the Supreme Court have a lot of power in terms of shaping public policy. The justices are in charge of interpreting the Constitution in regards to the issue at hand. They must decide what the language means of an act. So maybe they're rereading a law and they're trying to interpret what the language was intending. They also look at the procedures on which laws were made, or perhaps lower courts ruled on a decision. In a way, justices are, quote, making law when deciding how it applies to actions that aren't necessarily addressed by Congress. There's a debate in this country about how the Constitution should be interpreted. So one side of the argument says strict constructionist. Judges are bound by the wording of the Constitution, and therefore they must use judicial restraint. Sometimes we call this the original intent of the Constitution. Loose constructionists believe that judges should look to underlying principles of the Constitution and that they should use judicial activism. This is sometimes called evolving interpretation. It's not a matter of liberal versus conservative. A judge can be both conservative and an activist, or liberal and strict. However, today, most judicial activists tend to be liberal, and most strict constructionists tend to be conservative. Judges who use judicial activism create new constitutional rights. They might amend existing ones or create or amend existing legislation to fit their own notions of societal needs. Because remember, they're loosely interpreting the Constitution. They sometimes feel that the court should uphold a, quote, guardian ethic as a, quote, guardian of the people. There are many critics of judicial activism. They argue that it usurps the power of the legislature and that these judges are not elected by the people, so perhaps they don't have a place to be deciding what the people want in that, quote, guardian of the people. Judges lack experience in designing and managing complex institutions like schools or prisons, so when a judge tries to make a loose interpretation of the Constitution, it's possible that they don't have the experience in that field. In addition, oftentimes judges make initiatives in their rulings through judicial activism, and then those things that are created require money. Like in Brown versus Board of Education with the desegregation of schools, that would require, in a lot of cases, busing. And so a lot of critics say that judicial activism is not logical. Judges who use judicial restraint believe that judges should hesitate to strike down laws unless they are obviously unconstitutional, because they feel that the laws created by legislative bodies that were elected by the people, they believe that those laws are sacred. They allow the states and other two branches of the federal government to solve social, economic, and political problems. So instead of taking more cases and ruling on more cases, they kick it over to a lower court, or they kick it over to the legislature to decide on that law. They also believe that courts should interpret the law and not make it, so they do feel limited in what they can rule on. And judges who use judicial restraint decide cases based on what the founders would have wanted. We often call these constitutionalists because they are focused on the original intent of the founders of the Constitution. That is it for the judicial branch and the courts. We will cover actual court cases and go through this appellate process in our next class. See you later.